Hi everybody, Phil Brunner here again for, I'm not sure, this might be our 8th or ninth live Facebook into November, and next one will be November and then December, and then we'll have a break until February. So a couple more before Christmas, and boy has the year gone fast. So today we are going to talk about debt recovery. We'll certainly talk about a couple of steps in the process of debt recovery, and we'll probably follow up this broadcast with another one early next year about a few of the sort of more intricate issues in debt recovery, things like statutory demands and winding up proceedings, and we'll probably at that time also touch upon the concept of illegal phoenixing, where the laws in relation to that were amended, I think maybe late last year or earlier this year, to try and curtail illegal phoenixing. Yeah, a bit of an appetizer for you for next year. Okay, usual process. Our disclaimer. The information I'm going to talk about today is, as it said, information only. It's not legal advice, so you should not construe it as legal advice. Right, am I going too fast? Who is Bailiwick Legal? We're a firm that specialises in agribusiness and tourism, and we cover a range of legal issues from commercial, contractual, corporate, transactional law, property, estates, the whole gambit across those sorts of legal issues. The fact that we specialise in agribusiness in tourism doesn't mean we don't cover a whole range and spread of law. We do. Right, what's first for debt recovery? And when we talk about debt recovery, we're just talking about a situation where you are owed money by someone. It's as simple as that. So you've sold something and you haven't been paid for it. What do you do? Now, in a strict commercial sense, if you are a business trading out of the city, you'd most likely look to a debt recovery agency, someone that will do the hard yards for you, knock on a few doors, make a few phone calls, and try and cajole money out of the debtor, the person who owes you that money. In the sort of rural sectors, I don't think there's any, if any, debt recovery agencies that typically work in that sector, probably because of the distances required to travel, most likely. And my experience with this area is that most rural businesses, most farmers, tend to take matters into their own hands. They won't call a debt recovery agency. They'll make various phone calls, they'll send emails, and they'll take, often months and sometimes a year or two to try and badger, cajole, talk the debtor into actually paying the money to them. When all that fails, what do you then do? Some just give up, walk away. Where the debt is a substantial debt, and by substantial I mean sort of anything above $20,000, then walking away can actually be quite an expensive exercise. You are effectively walking away from recovering $20,000, which in the scheme of things is a reasonable sum of money. A lot of farmers and businesses within the rural sector probably don't realise or think that a law firm might be able to help them with those types of debts. In fact, many law firms, including ourselves, treat these as sort of bread and butter. debt recovery is something that is done day in and day out for law firms like us, and the process, is not actually very difficult. So, why would you engage a lawyer in the first place? We think that there are a couple of very good reasons why to engage a lawyer for debt recovery purposes. And the first of those, in no particular order though, is that the quicker you actually action trying to recover your debt, the more likely you are actually to recover the full amount. And I think we've all come across circumstances where someone who owes you money ends up in bankruptcy, or if it's a company, they go into liquidation and winding up, and there's no money left for anyone. So it's really important to get on to debt recovery really quickly. And engaging a lawyer can assist you with that, because it takes that away from your time. You don't need to worry too much about it. You give the issue to a lawyer and give them the information, and they do the work for you. Secondly, there's a limitation period for collection of debts, so time is quite critical in that context. The third, perhaps more important reason is that typically, self-represented litigants and debt collection agencies don't understand the process of court applications. They don't necessarily understand the procedural requirements of commencing court action to recover the debt. And so lawyers, because that's part and parcel of their job, they understand the processes of commencing proceeding and the nuances involved in doing so. Another factor in relation to debt recovery services is that they take a percentage of the debt that's actually recovered. Legal costs, and that percentage is not then payable to you. Compare that to a situation where if you're actually using a lawyer, those costs that are incurred often are recoverable. Now, you may not recover all your legal costs, but at the end of the day, that process may actually be a less costly situation than if you were to do the exercise yourself or engage a debt collection agency. Okay, so at Bailiwick, we do have the ability to assist in debt recovery. As I said, we've been doing that for quite some time now, and we have some experience with those types of actions. So what's the first step? The first step invariably for us when we're looking and being asked to recover a debt is to prepare and issue a letter of demand. That's a formal process, and what we do there is we collect the background information, copies of all the transactions that prove the contract, that prove that there's a debt owing, get all that information together, drop that into a letter, identify the cause of action, right? The cause of action may be simply a debt due, it might be a breach of a contract, and lastly, within that letter, we make demand for payment. Now, depending on the circumstances, that demand for payment may be, we'll give you 7 days to pay this debt, or we'll give you 14 days to pay this debt, or we might give you a longer period of time to pay this debt. Sometimes we actually put an offer in that letter as well, and that offer would typically be without prejudice, but it would be a mechanism to try and engender a quick and speedy resolution to the dispute, because at that point you are in dispute. Right, the letter of demand itself is quite an effective tool. We've found it in the sense that it's a formal written document that creates that demand from the first place. It's coming from a lawyer. Now, in many senses, the novice out there, in receipt of a letter from a lawyer, creates a fair bit of stress. And that's what it's designed to do. If you get a letter from a lawyer, you immediately think, what have I done wrong? And so, from that perspective, it's effective because it immediately brings the issue to the attention of the recipient. The demand also, because it has a strict time compliance window, in the sense that you're asking for the debt to be paid within a particular point in time, then gives you, as the person who's owed the debt, an effective window. You know that at a particular point in time in the future, if the debt has not been paid, you have the right and the ability then to take the next step. And that next step is the commencement of proceedings, which I'll come to shortly. One of the other important things that a letter of demand holds or contains is a notification to the debtor that if legal proceedings are required to be taken because the debt is not then paid, that in the event that proceedings are required, that the person seeking to recover the debt will seek their full legal costs plus interest. And that's quite an important aspect from 2 points of view. One is that there's an interest component. So in court proceedings, a person can claim interest upon damages or a debt at the court's specified rate, which at the moment is 6%. And that interest component will start to accrue from the date the proceedings are commenced. And so that becomes a negative for the person receiving this letter, is that they're immediately then alerted to the fact that interest may be payable on any court-based outcome. The other aspect that I mentioned there is costs, in the sense that by issuing the demand, you've effectively raised the issue of the dispute. You've given the person an opportunity to rectify the dispute, remedy the dispute by paying the money that's due. And if you are forced to then commence proceedings, you can then approach the court later on, once you succeed in that proceeding, to ask the court to have all your costs, your solicitor costs, paid, because you gave the person the opportunity to fix the problem very early on, and they didn't. So another aspect to the letter of demand, and something that we often put in the demand too, is that if the demand is not met, the matter goes to court, a judgment is made against the debtor, then that judgment becomes a flag for the debtor's credit rating. Now, it's an interesting situation, this one, because the law was changed earlier this year such that credit agencies are not meant to list a person or entity on their list as let's say a bad debtor, unless there's been a judgment, a court-based judgment against the person. And so when financiers typically go to credit agencies and seek a credit report against someone, it's only judgments that will be shown. Now, we're aware that, notwithstanding that legal position, credit agencies still do flag people that have proceedings against them. So from a financier's perspective, they're not meant to take account of that as a bad credit risk, but one suspects that that does actually happen. So simply being named in a proceeding may well affect someone's credit. And that can often be quite a big tool in favour of the person trying to collect the money. Right, okay, so you've sent the letter of demand, or we have for you. What then happens? Well, obviously a range of things happens. Either from the demand is ignored and you hear nothing, to the demand is paid and you're satisfied, or somewhere in between there. So we've had situations where we've had letters of demand issued, and the person who's received the demand has contacted us and sought to resolve the dispute, and then you're in a negotiation. And conceptually that's the best place to be, because you've got there pretty early, and even if you do compromise the debt to a degree, at least you get a resolution out of the issue. The worst case scenario is that you actually have to commence proceedings to seek to recover the debt because the person either denies the debt or doesn't pay the debt or simply ignores you. Of course, sometimes, and this is perhaps the rare occasion rather than the norm, sometimes the debtor simply doesn't have any money. Before we issue a letter of demand, we'd like to be able to check the resource availability for that debtor. We try and do some background checks to see whether the debtor actually has any money or has assets to satisfy the debt. So that's a bit of a check that we would do prior to issuing the letter of demand. And based on the outcome of that information, that can sort of affect how the whole process of debt recovery proceeds. So you've issued the demand, and for whatever reason you've not been paid. What then do you do? At that juncture, you have quite a serious question to answer. Do you commence legal proceedings and take that more formal step, or do you not, and do you just let things go? The advice we provide to clients in this situation is, if you're not prepared to take that next step, think seriously about issuing a letter of demand in the first place. It's more akin to, if you want to talk the talk, be prepared to walk the walk. So that's the attitude we take to this. If you're serious about trying to recover your debt, be prepared to take this next step and commence court action if that becomes necessary. All right, well, what does that actually mean then? So that then brings forth this choice of which court do we go to. And the courts have a hierarchy of monetary limits which determines which court you're in from a purely debt perspective. So if we're talking about other claims like equitable claims, you may be limited to simply that at the Supreme Court to commence, but for debt recovery issues, the full three-tiered of the court system is available to you. And by that I mean, for claims under $75,000, you will commence in the Magistrates Court. And the benefit there is that there are magistrates courts in Geraldton, Mora, Narrogin, Katanning. I think there's one in Esperance too. So there are a few magistrates courts, Northam as well, that are around where you can actually commence close to you. And we can still assist you with that because these types of claims can actually be filed, and typically are filed electronically. rather than actually fronting up to the counter at the courthouse. So, as I said, claims for $75,000 or less, magistrates court. Now, there's a bit of a skew in there too. So, for claims under $10,000, a person can utilise what's known as the small claims procedure in the magistrates court. Now, there's a bit of a trap in that under the small claims procedure claims, a party cannot be represented in court by a lawyer, but a lawyer can assist you outside of the court process. The real problem there, of course, is having a lawyer act for you for any of that process is going to cost you. So for a claim under $10,000, you need to be super cautious about how much costs you're trying to incur or you're going to incur. And we've acted for clients in this area, but typically we go very cautiously. We provide the minimum advice and assistance as possible to limit that cost impost to the client. The second issue is that those legal costs, if you are represented, may not be claimable. Right? The base position in the small claims sector is that legal costs are not recoverable. They will be in certain circumstances, and it can be a bit of a hurdle to get over those circumstances. We have recently been successful in getting legal costs in a small claims environment. We were successful in defending a claim that was made by a person who simply did not have any claim against this particular defendant. We applied to get on the record. We were granted that. And of course, subsequently, the court also granted our client legal costs. It's a rarity, but it can happen, but don't bank on it. So, as I said, the next monetary level is for claims between $75,000 and $750,000. You would commence proceedings in the district court. Claims above $750,000, you will commence in the Supreme Court. Now, the district court and the Supreme Court actions are pretty much the same. Both those court processes are governed by, typically, the Supreme Court rules. In the district court, there are a few court rules that are different to the Supreme Court, but by and large, it's much the same. Legal costs are generally recoverable to a successful party. In the magistrates court also, where your claim is not within the small claims area, legal costs will be recoverable to the successful party ordinarily. The processes within those respective courts are reasonably straightforward, at least in the context of commencing an action. In the magistrates court is a general procedure claim. In the district court and the Supreme Court, it's usually going to be a writ with a statement of claim or a writ with an endorsement of claim. The whole processes within those courts is probably something we'll deal with at a future point in time. So that's sort of the snapshot of debt recovery at a very basic level to get you into a court process. And provided that there is sufficient, cogent, substantive evidence that the debt exists, then your prospects of success within the court process is going to be quite high. Your ability then to get a costs order against the debtor is also high. Your ability to get interest on the debt is also high. So whilst it may seem daunting to proceed in that way, there are benefits for commencing action where there is a substantive debt owed to you. So as I said earlier, in a subsequent broadcast, we'll go through illegal phoenixing, we'll go through statutory demands, and we'll go through winding up proceedings, which are different ways of approaching debt recovery, and particular circumstances as to why you would approach debt recovery in those different ways versus simply commencing an action for debt recovery in one of the courts. So until then, feel free to reach out to us to discuss any debts that you may have outstanding and wish to gather. We do provide free consultations to assist in this area, to help put your mind at rest, and to see if you have a substantive claim to proceed further with. We try to, at Bailiwick, provide advice and assistance based on a common sense and commercial approach to the disputes involved, and we look for practical outcomes. We do have experienced people within the commercial property, employment and succession law space, and we're a growing team, but we still look to work in a team environment. So that's it for me today. Keep well and keep safe. Thanks.